second session. Please be seated.
Thank you, Madam Clerk. I neglected to announce before our recess that the Derek Morse case that was taken off the docket and will be reset at a later date. And so that means if my notes are correct, we still have one case this morning. You will call that case, please, Madam Clerk.
Yes, sir. State of Tennessee versus James Leon Parker.
See, are you Miss Butler?
Yes, sir.
Good morning.
Good morning, Your Honors. May it please the Court. Jessica Butler with the Appellate Division of the Public Defender's Conference. On behalf of the appellant, Mr. Parker. Judge Wiedemeyer, if I could request 4 minutes for rebuttal.
4?
4, yes,
All
sir.
right.
Thank you.
Certainly.
Today, we are asking this Court to grant a writ of cert, find that Mr. Parker was statutorily entitled to a hearing on his motion for resentencing, and remand this matter back to the trial court. So I'll lay a little bit of background first, and then I'll get into the reasons for the writ. But Mr. Parker was convicted in 2008 on several drug-related offenses, the most pertinent of which being sale and delivery of 0.5 grams or more of cocaine within 1,000 feet of a school. So at the time, that was under the Drug-Free School Zone Act, that was a required mandatory enhancement, as well as a required mandatory minimum sentence. In 2020, the state legislature amended the Drug-Free School Zone Act, and they reduced the distance from 1,000 feet to 500 feet, and also removed that mandatory enhancement, and created a rebuttable presumption that the defendant was not required to serve the mandatory minimum sentence. The legislature amended the statute again in 2022, this time implementing subsection H, which created a process for defendants to be resentenced under the new drug-free school zone statute. And Mr. Parker filed a motion under that subsection H, in June of 2022. About the same time, Governor Lee also implemented a clemency process that allowed individuals to seek executive clemency from his office on the same offenses. So while Mr. Parker's motion was pending in the trial court, Governor Lee commuted his sentence to immediate parole eligibility. The following month, he was back in the trial court to be heard on his motion for resentencing, and at that point, the trial court concluded that because he had been granted a commutation, he was ineligible under the statute and dismissed the motion without a hearing.
I have a factual question.
Yes, Your Honor.
The request for clemency to Governor Lee, did that request include any other relief? Or can you tell me about that request? Are specifics about that request in the record?
There's nothing in the record about what was requested. There's no paperwork there's no clemency paperwork in the record. The only thing that we have is the governor's commutation order, which essentially just says that it's reviewed the facts of the case and that Mr. Parker, under those facts, is eligible for parole immediately.
Do you see that as the governor granting clemency then?
I do, and that's part of our argument now, is that the statute, the portion of the statute that the trial court relied on states that an individual is not eligible for resentencing if they have gone through the clemency process and been denied. And it's our position that the commutation is not a denial, but that there is still additional relief available. So that subsection would not apply, is our argument today.
You are becoming the Section H guru for the state of Tennessee. It seems like you have all of these cases.
I have a couple, but I actually think Mr. Ward might be the state of Tennessee's expert on that. But I do have a few as well, Your Honor. That's
a compliment, General.
When a judge says you've become the guru, you accept it and say, yes, I have.
I do want to give full credit to the state as well, but we have both had several of these cases. Yes, Your Honor.
Gotcha.
So because the court at this point has made it pretty abundantly clear that we do not have a right of appeal under Rule 3, at the time that we filed our principal brief, there were 2 unpublished decisions. One of those has since been published. So we're asking the court today to hear this case under a writ. And I do want to point out that there are 2 recent cases that address this issue specifically. There was a case filed 2 weeks ago, State versus Patton, where the court granted a writ. And then there's another case that was filed, I believe, last week.
Friday.
Friday,
Last
yes.
Friday.
Friday, yes, Your Honor. Where the court denied the writ. So there is some case law that says that a writ is appropriate in this instance. I do want to point out that the sort of single distinguishing factor between our case and all of the other cases, as far as I can tell, that the court has heard on this issue is that this is the only instance in which the defendant was outright denied a hearing. In all of these other cases, the defendant is asking the court to basically engage with the trial court's discretionary decision with regards to resentencing. In this case, we are only asking the court to remand this back so that the trial court can go through that resentencing procedure. So we are not asking the court to engage on the merits, although Mr. Parker's motion is in the record and the court's free to look at it, but we are not asking the court to engage on the merits. We're not asking the court to make a decision regarding a discretionary decision from the trial court. We're only asking the court to remand this back so that we can have our day in court, essentially.
2 things. If you get back to the trial court, if I read the briefs correctly, your brief, even though your client got some pretty substantial relief from the governor,
Yes, Your Honor.
There's additional relief that he potentially could receive. Is that right?
That's correct, yes.
Okay.
So Mr. Parker's sentence on the drug-free school zone convictions initially was a 25-year sentence. He's already served well over 15 years of that. And if he were to go back and be resentenced today, he could effectively be resentenced to time served. So he would not be serving that additional 10 years or so on parole. So there is greater relief available to him,
All right.
yes.
And the statute says there shall be a hearing.
The statute does say shall, Your Honor, that there shall be a hearing. And there are obviously things that the trial court can consider, and it does say that the trial court does not ultimately have to grant resentencing, but that there shall be a hearing on the motion. And that's all we're asking for, is the opportunity to be heard on that motion.
I want to be sure I understand this other part too. It says there's no hearing if he's taken his best shot with the governor and been denied.
Correct.
But this client was not denied.
That's correct, Your
Came
Honor.
out pretty
This is
well.
a very rare instance where he has not been denied. He has been granted some form of clemency, but there is additional relief available to him, and we're only asking for the opportunity to be heard on that motion as the statute requires.
All right, thanks.
So, but the state suggests in their brief that your issue now is moot because he was granted clemency. Why is that not true? Why is this issue not moot?
Well, I think because he's still serving a sentence, Your Honor. He's
on parole.
Correct, but he is still serving a sentence. And there are obviously some limitations that come with parole. He's still under some form of
Well, I
watch
think
from TDOC.
case law backs you up on that.
Correct,
as
Your Honor.
well. I just don't know how that fits in this statute.
I agree. I'm pivoting.
Okay.
I didn't want to
If I could just address that very quickly.
I just don't know if a lesser sentence under this statute means something other than parole.
I think sentence means sentence.
Okay.
And
case law
parole is
backs
still
you
a
up.
sentence. Correct, Your Honor, yes. Judge McMillan, I want to get to you.
I was just curious, I'm going back to my initial question. The governor was aware of these circumstances, or we got to presume that he was aware of the, I guess, the lesser sentence that's available to your client as well, right? 'Cause
Correct.
from the state's brief is that all, or at least my interpretation from the state's brief, is that all of the relief was denied, given the clemency order or the commutation. And that's one way to look at it, right? So that would kick you out of the statute.
I think it's fair to assume that the governor was aware that there was additional relief available. But our position would be that he was granted some form of clemency, and it's not an outright denial. And because the statute states that the defendant has to be denied clemency, it doesn't go into further detail about that, that we have a commutation order from the governor stating that he was granted clemency. So that's not a denial. Obviously, there was additional relief that was available that was not given, but that's not an outright denial. And because it's not an outright denial, the statute requires that he still have the opportunity to be resentenced in the trial court.
Does the clemency order in any way, by language or inference, I don't know, address that granting this clemency is in, quote, the interest of justice? Is that language
I believe that language is in the commutation order. I'd have to double check.
The commutation.
I don't want to say for sure, but
that's
I'm
what the
almost
statute
certain.
envisions, is a consideration of what's in the interest of justice.
Correct. I'm almost certain that the commutation order does state that it would be in the interest of justice to commute his sentence.
But doesn't that make this moot now? That there has been a finding that this resentencing is in the interest of justice, and the resentencing is you're eligible for parole?
I don't think so, Your Honor. In fact, I actually think it cuts the other way, that if we were to get back in front of the trial court, we've already established that it's within the interest of justice to be sentenced to something less than he was already sentenced to. So I take your point, but I don't think that it would be moot simply because the governor's already stated that it would be in the interest of justice. I think looking at the plain language of the statute, he's still entitled to a hearing, and if we were to get back in front of the trial court, I think that we would have a strong argument that it is within the interest of justice to be resentenced to something less than the 25 years. Well, if the court has no further questions, I will leave it there. I'll await rebuttal. Thank you.
All right, thank you. General?
Good morning, Your Honors, and may it please the Court. My name is Garrett Ward. I'm here today on behalf of the state of Tennessee. Your Honors, this case is just the most recent in the sort of long line of cases that have sprung out of the amendment to the Drug-Free Zone Act. If my recollection is correct, this is the fifth time I've dealt with one of these denials.
You're applying for deputy guru on this?
If that position's open, I throw my name in the ring.
I think we can grant it to you from the bench, I think. Go
I'll
right
take
ahead.
it.
Yeah.
Your Honor, this it appears that both parties are in agreement that pure right of appeal under Rule 3 is settled here under Bobo. So I won't spend any time belaboring that point, which means the defendant can only get before this court should this court choose to exercise this rather extraordinary judicial tool of the common law writ of certiorari. As opposing counsel has rightly noted, there is some case law, the Patton case, where the court did consider a challenge to resentencing under the writ of cert. Relief was denied in Patton. And then last week in Pody, this court looked at a denial of resentencing and concluded that.
But in that case, we concluded that writ was the proper way to get here. The remedy was not granted, but we did find that writ of cert is the way to get here on these cases.
And I'd agree, Your Honor. It appears to be the only potential way to get here on these cases.
Which, from your standpoint, from the state standpoint, I would think would be good news, because that standard is so much higher than a regular appeal. It's beyond abuse of discretion. So I would think from the state standpoint, you would be satisfied that we're looking at these through the lens of a writ of cert.
And Your Honor, in principle, with depending on the case, I don't think the state takes issue with that. I'd suggest, Your Honor, that in this case, deployment of the review under the writ of cert isn't necessary.
Because?
What we have here, Your Honor, is at its core a debate between the state and the defendant over whether or not the trial court properly interpreted the second to last subsection of subsection H. I think really there are two subsections of subsection H that are at issue here. There is part of subsection H that says the court shall hold an evidentiary hearing, and then lists some what should be considered that hearing, things of that nature. Then in a subsequent subsection, it says the court shall not entertain a motion under subsection H, so language speaking to sort of summary denial, if certain circumstances are met. What the disagreement in this case is principally about is, did the trial court appropriately interpret that shall not entertain language, and did it properly interpret one of the circumstances under which this resentencing motion under the amended Drug-Free School Zone Act shall not be entertained? One of those is if there has been a denial of a request for clemency from the governor. And I want to note from the beginning, what the statute does not say is if there is a full denial. The General Assembly certainly could have written a statute that says if the governor completely and outrightly denies the statute or denies the motion, it shall not be entertained. But if he partially denies it and partially grants it, it can be entertained. The General Assembly could have written that statute. It didn't. It just said shall not be entertained if there's a denial. And, Your Honors, I think it's sort of tough to square the circle here. If the circle is a partial grant is not also a partial denial. Opposing counsel appears to concede, and I think rightfully so, that there was other relief available to Mr. Parker, and that the governor would have been aware of this other relief, and that he decided sort of almost a middle-of-the-road approach was best. He granted substantial relief to this defendant. This defendant is now not in incarceration. This is significant relief from the governor, but the governor didn't grant full relief. If he didn't grant it, he denied it. That language may not be, that may not be on the fancy commutation order granting defendant his relief, but it's there in between the lines, and inescapably so. The governor in this case made, as the commutation order does say, sort of an interest of justice determination, exercised his broad clemency powers under the Tennessee Constitution and statutes, and granted a certain amount of relief. And the defendant's request is at its core asking for this court to grant the trial court the ability to essentially review the governor's decision and say, no, governor, you should have granted more. And, Your Honors, that notion is expressly decried against in the statute itself. What the statute says is a trial court shall not entertain this motion if the court has denied clemency. What the General Assembly is concerned with there, just looking at the plain language of what they've done, they do not want trial courts to use resentencing motions under subsection H to examine clemency petitions that have been considered by the governor, where the governor has said there is some amount of relief that I, as the chief executive officer of the state of Tennessee, with these broad commutative powers under the Constitution, think is not warranted. General Assembly, when they wrote this statute, expressly forbade trial courts from being engaged in that practice. And I think in this case, we have a partial grant of relief, substantial relief. We also have a denial of further relief. The sentence wasn't fully commuted. The defendant is still on parole. The governor could have made that not the case, and he chose not to. and the defendant is asking for the trial court to have the ability to essentially re-examine that decision made by the governor.
So where are you? I'm not sure I know exactly where the state stands on this. Do you think that granting partial relief is being denied clemency, or is granting clemency?
Your Honor, I think the state is in a position where it's both. You know, there has been a grant and there has been a denial. Almost the use of the term partial grant, by definition, indicates that there's also been a partial denial. It's if it's a request for 100 of some objects and 50 are granted and 50 are denied, then it is both a grant and a denial. Those two concepts aren't mutually exclusive when you're dealing in relief that can be partially granted or denied.
All right, so we've got a sentence imposed by a criminal court.
Mm-hmm.
Then we have a request to the governor for some relief on the sentence. The governor acts, says, now the sentence is changed. It's now this sentence. And the defendant says, thank you very much, but I would also like to have my hearing that's mandated by statute and let a criminal court judge in the judiciary branch, we're talking executive action, now we've got judicial, we're back to the judiciary branch. All I would like is for the criminal court judge to now look at what my sentence is. I mean, that it's still a sentence.
Certainly.
Right. I mean, that you can put a question mark by that if you want. But here's a sentence. And now I would like the criminal court judge to do what he's supposed to do under the statute and give me a hearing, I mean, if you go with their view of it, and possibly modify the sentence even further. Mm-hmm. The problem I'm having, I understand your position is if he says, the governor says, I've looked at this and I'm going to grant this, and what you're saying is basically by implication, I've looked at the whole thing and I'm granting some relief, but between the lines, therefore I have denied any other relief that you've asked for.
Because his powers would have gone further than the relief that was granted,
Okay.
Yes.
All right. And so he sends it, I mean, I don't know if he sends it back to any place, but this defendant now has a changed sentence, and it has been changed to his benefit, mm-hmm. To some degree, and not to his benefit in another degree. So, the problem I'm having is with why should a criminal court I probably imposed the original sentence, why they shouldn't, at his request, take maybe what you would call a final look at the outcome here and see if there's anything. And if I were going to bet on it, I would bet he might not get any more relief, but that's outside the record.
Certainly.
But at least give him why would the state say he shouldn't at least get a shot to go before this criminal court judge? And I keep emphasizing, we're talking about the judicial branch of government. Our full-time job is to deal with sentences.
Certainly, Your Honor.
Yeah, and I respect, of course, the governor and his power to commute sentences and things like that, but I'm not quite sure why the state is opposed to the criminal court judge taking yet another look at it.
Is this a separation of powers issue is what I think my colleague is getting at? That's what I'm getting from what he's saying. Is there a separation of powers question here?
I don't believe so, Your Honor. So the sort of the existence of the resentencing motion is a creature of statute. It's a remedy created by the legislature. One of the limitations on this remedy, yes, certainly in the normal context of these motions, there must be a hearing. One of the limitations on this, and this is all spelled out in the statute, the court shall not entertain such a motion if one of these circumstances is present. So when the legislature creates this remedy, the legislative branch creates a remedy and, assigns sort of administration of that remedy to the judicial branch, but as a consideration on the remedy they've created, says that this remedy isn't to provide a mechanism for providing a final look or a review of a governor's decision. To me, that all seems to be business proceeding as it should. The legislature didn't have to create any remedy. The legislature didn't have to do anything to allow for this motion for resentencing. I'll note for the court, and this isn't in the record, but I can speak on this to some extent. There was the principal existence for subsection H in the resentencing motion is the governor's office was inundated with clemency requests because the Drug-Free Zone Act had been amended in, I believe, 2020. It's been amended a number of times. I think 2020 is the operative one here. There were, and it made it a less onerous statute. Lots of defendants were seeking clemency from the governor. The legislature then created this ability to seek resentencing under subsection H with the judicial branch, but attached to that this sort of specific ticket that says, if the governor has already said no, this remedy isn't available to you. That's certainly well within the power of the legislature to do when they create this remedy that wasn't required to attach this sort of condition to it. So maybe that's a roundabout way of saying, Judge Wiedemeyer, that the reason the state believes that the defendant shouldn't get a final look is because that's what the statute says shouldn't happen. That if he gets a denial, and I forcefully contend to this court that when the governor decides to give him some relief, but not all relief, that is a denial. The statute says the motion shall not be entertained. If there's a denial, then it shall not be entertained, and that's in the notion of summary that's in the language of summary dismissal. So I believe the language of the statute itself says that in these circumstances we don't need a hearing. In the normal set of circumstances, Judge, certainly a hearing is required, just not here.
Can I ask something else? I'm not really all that familiar with clemency law, but is this fairly routine to have partial grants of relief basically in a clemency order?
Your Honor, I can't, I've seen a few clemency orders in my time at the AG's office. It's obviously the governor's office that processes those, not ours. It's within the governor's power to do, but I wouldn't want to represent to the court the frequency with which the governor takes a middle of the road versus all or nothing approach. That's just outside my realm of expertise.
You did a good job answering my question. I understand your position, and I think Judge McMullen has hit on, I think, what's kind of troubling me also. If you just kind of glance at it and you say, all right, our job is to sentence criminal defendants. We've done it. Now we've got some issues about the drug-free zone, and we're going to blah, blah, blah. So we've done this, and then the legislature says, oh, by the way, we're going to let the governor, we're going to have the governor involved in this and can grant clemency. And like Judge McMullen, clemency is pretty hazy to me, but I would think would be, just as a man on the street, it would be, oh, we got clemency. We're done here. There's nothing else. We're free. There's no more restrictions on anything. This is a great day for this Mr. Parker. But in fact, there's additional relief that he could be granted. And so in my mind, I'm thinking the criminal court judge should be the one to be looking at that now. The governor's done his, whatever he wanted to do on it, but that doesn't, in this case, it didn't just end it. it's still something sitting there to be dealt with. But you've explained your position on it. The statute. The state's interpretation is the statute, it's ended by that statute. I mean, he went that route, he got some relief, he was denied other relief, therefore that's done, and once that's completely done, there shall be no hearing for additional relief.
If a motion may not be entertained,
Right.
if relief from the governor has been denied,
Okay.
then
Or language to the effect of, if a clemency petition has been reviewed, is really what you're asking us to interpret that language as.
I wouldn't want to say just reviewed, Your Honor, because I think this is probably the case for a good deal of defendants like Mr. Parker, that these proceedings were going in parallel. For Mr. Parker, the governor rendered a decision. It wasn't just that he looked at it, was in the process of looking at it, rendered a decision. I certainly wouldn't want to suggest to the court that just being in the review process eliminates one's eligibility for this statute. That's not the state's position. But the language used in the statute, yes, it does say denied. There are a number of ways perhaps that statute could have been worded. But what the statute says is denied, and Judge Wiedemeyer, Judge McMullen, as you've noted, there is more the defendant could have gotten here, and the governor elected not to give it to him. To me, that smacks of denial, and under the statute, the motion therefore shall not be entertained. So for that reason, Your Honor, I would ask
Well, but let me ask one last question, if I can.
Certainly.
Since we're looking at this now, it seems like everyone agrees to a writ of cert.
if there's a way to look at it, yes, Your Honor.
If there's a way to look at it, okay. A writ of cert is granted when defendant was denied his day in court. That's one of the reasons. And I guess looking at this in my small-minded way, wasn't Mr. Parker denied his day in court?
I'd say no to that, Your Honor, because yes, the law around the writ of cert does use the phrase day in court. But what Mr. Parker did get here was his motion was in front of a judge. The judge had a statute that he had to weigh this motion against. Because the statute itself, by its language, says that no, there's no hearing, it was still considered by a judicial officer who found he was ineligible. I don't think the writ of cert can be deployed to just ignore the language of subsection H. To the extent he didn't receive a hearing, that is pursuant to the law of subsection H itself. The court has to compare this motion to the statute. The court can't choose to ignore the shall not entertain language in this statute, and I don't believe the writ of cert.
But the language of the statute also said has been denied. And in this case, it was granted. Clemency has been denied. And in this case, it was granted. And he got his cake, but he didn't get the icing on the cake. And that's what it sounds like he's asking for. Now he wants to go back to see if he can get icing on that cake that he got in his clemency.
Your Honor, I'd say that that's more or less correct, that he got his cake, but he didn't get his icing because the governor elected not to give it to him.
Okay.
And to me, that's a denial.
That's a fair argument.
If there are no further questions, I would ask that you.
The pound cake, it doesn't come with icing. Okay.
I didn't necessarily want to speak on the vast realm of confectionery creations that may or may not have icing. I am not the state's guru on icing.
You're ready to resign your deputy guru spot by now, I bet. Cake analogies are I always like those.
I'll never
Good.
complain about cake, Your Honor. If there are no further questions, I would ask that you affirm.
All right, thank you, General. Counselor, you got some rebuttal time left, I think,
Thank you, Your Honor.
certainly.
Just a couple points I want to make. First of all, Judge Easter, I did have an opportunity during the state's argument to look at the commutation order, and the interest of justice language is not specifically there, but the commutation order does say that the circumstances of Mr. Parker's offense do not warrant enhanced sentencing under the Drug-Free School Zone Act as amended. A couple things. We've been going back and forth about whether this is a denial, an outright denial, a partial denial. The language of the statute says denied, and to Judge McMullen's point, I think if the legislature did not want individuals to have the opportunity to go back, then they could have either just left out the "and been denied" portion of the statute, or turned it into something else, like maybe not been reviewed, but you've received something from the governor already. So not necessarily the "and been denied," but to say if you've gone through the process and you've received an answer from the governor, then you can no longer go through the resentencing process. But the statute does say "been denied," and I think in terms of whether this is a denial, a partial denial, I think the governor had several options before him. So typically, I believe clemency, you can either receive an exoneration, a pardon, a commutation to time served, a commutation to parole eligibility, or an outright denial. And so we have one of the commutations. There are two options. The governor can either commute to time served or commute to parole eligibility. He opted to commute to parole eligibility, but that's not an outright denial. That is one of the four options available to the governor. So this is it's not even a partial denial. He chose one of the options available to him. Obviously, it's our position that if we went through the resentencing procedure, Mr. Parker has additional relief available to him, but that is not a denial, partial or otherwise, because it is one of the options available to the governor at that time. The other thing I just want to briefly mention is that the state essentially argues that the executive clemency is Mr. Parker's day in court. That is not a day in court. That's a completely separate process, and the statute was amended for the specific reason to allow defendants to go back to the trial court from which they were sentenced, to have the opportunity to go in front of that judge who likely is familiar with that case, familiar with the circumstances, and to make the argument on the motion, present any evidence, any exhibits. Obviously, Mr. Parker's motion contains several exhibits attached to it. So the trial court, the process is designed for the trial court to have that opportunity, as Judge Wiedemeyer pointed out, to have that second look at it from the perspective of being familiar with sentencing procedures and determining whether or not the individual is someone who is an appropriate candidate for resentencing. And the other point I just want to briefly mention is that the trial court's belief here was that he did not have the authority to resentence Mr. Parker because he had been granted clemency from the governor. In the transcript from the resentencing hearing, such that it was, the trial court actually states that Mr. Parker's request for clemency had been approved, and that the trial court believed that made him ineligible for resentencing. So the trial court's belief here wasn't that Mr. Parker's already had his opportunity, and so I don't want to engage in the resentencing. It was that Mr. Parker has been granted clemency from the governor, and that request has been approved, and a reading of that statute, I see I'm out of time, I'm going to go very quickly, and that the trial court's reading of that statute was that he was ineligible, but essentially did not read that "and been denied" portion the way that we believe it should be read. So if the court has no questions, I'll just ask the court to grant cert and remand this back to the trial court. Thank you.
All right, thank you. Well briefed by both sides and well argued as well. We appreciate it, and we'll take the case under advisement and be in recess till 1:30 this afternoon, I believe.
Yes, sir. All rise. Court is in recess until 1:30 this afternoon.